it's getting quite intense for the suspended Deputy Chief of the Ekurhuleni Metro Police Department, Julius Mkhwanazi, who was today arrested for the 4th time this year alone. In fact, the 4th time in 4 months. In a moment, we'll talk to senior legal practitioner and legal expert Zola Majavu to unpack it all. But before we do that, let's just go through some of the facts and figures around this arrest. As we say, until today, there were 3 cases that were pending against Julius Mkhwanazi. And it's at 3 separate fora. So basically, it involves litigation and appearing in courts in various areas. The first one stemming from his arrest, I think it was the 18th of April this year. That forum is the Boksburg Magistrates Court. Around July, he gets arrested in connection with the precious stones matter. That matter is before the Johannesburg Magistrates Court. Then there's a 3rd case that has to do with the testimony that came out of the Madlanga Commission of Inquiry around the installation of blue lights on the private vehicles of the security company belonging to Vusumuzi Ket Matlala. And that matter is before the Germiston Magistrates Court. So there you have it. In total, he has paid up to 85,000 rand in bail. And that raises the question that we will be asking to Zola Majavu in a moment about whether or not, in a situation where someone is already out on bail, is it strictly necessary to arrest that person? And of course, he will talk to that and talk to whether or not the gravity of the case involved comes into it. Let's go through the cases one by one. This is the first arrest that actually occurred on the 18th of April. It has to do with a scheme that the state alleges was cooked up between parties that include Julius Mkhwanazi and the municipal manager in Ekurhuleni, Kagiso Lerutla, in which case Mr. Lerutla is alleged to have conspired and working together with Julius Mkhwanazi to get an impersonator, someone to impersonate Mr. Lerutla. Instead of Mr. Lerutla appearing in court, this person would appear in Mr. Lerutla's in his stead on a matter that has to do with a speeding offense that had allegedly been committed by Mr. Lerutla. That case will be back before the courts on the 21st of August, and that is the case that is in the Boksburg Magistrates Court. Then the next case is the almost 15 million rand precious stones case. It stems from an incident in Killarney in Johannesburg, where some of the accused, along with Mr. Mkhwanazi, include current and former members of the Ekurhuleni Metro Police Department. Kesha Lee Stalls is a former member, but also you have someone called Adrian Mackenzie, who is on suspension, an EMPD member on suspension. That matter is before the courts on the 25th of August, and that is the matter in the Johannesburg Magistrates Court. Let's fast forward to the 3rd one. This is the one that has to do with the precious stones case. It is linked to the evidence at the Madlanga Commission of Inquiry. It has 4 accused, including former city officials, and that matter will be back before the courts on the 25th of August. And this is the matter that is in the Germiston Magistrates Court. And then lastly, quick recap. It's hard to believe that just a couple of months ago, Julius Mkhwanazi was someone that few of us would have known, right? But he's found himself becoming a figure that is at the heart of many of these allegations, certainly coming before the Madlanga Commission of Inquiry. His first appearance was in December 2025 before the Madlanga Commission of Inquiry. As I said, being arrested twice in the space of a month. That happened in July, and of course, he's going to have a very busy month in August, appearing at those 3 fora. Add to that a 4th one following the arrest that happened today, which is the 4th arrest of Julius Mkhwanazi. So let's pick up then the conversation with legal expert and senior legal practitioner Zola Majavu, who joins us now. Good evening to you, Mr. Majavu, and thank you for your time as always. Let's start with this. Reconcile for us the consistent arrests that we see of Mr. Mkhwanazi, and in light of the fact that he's already out on bail and several amounts have been paid, and we're reporting they come up to over 85,000 rand, and arrest not being the only method of bringing a suspect to court to stand trial.
Good evening to us, and good evening to the viewers at home. Firstly, it is unfortunate for Mr. Mkhwanazi, but unfortunately, that is precisely how the rule of law operates. The fact that he's already out on a number of bails in respect of separate matters does not mean if there is evidence of alleged wrongdoing, again on a separate set of facts, he would not necessarily be processed in the normal course. He would be, which is why in this particular instance, he will most probably spend the night behind bars, and he will probably appear before court tomorrow, whereat he would bring a bail application, which may or may not be granted for whatever reasons. Ideally, if these charges were emanating from the same set of facts, one would have just expected the state to add on to the existing charge sheet. But as you rightly pointed out, they arise from completely distinct set of facts. And this is precisely why he has to be processed individually for each count in respect of which he stands accused. And that's just the way it is. And one cannot also discount the possibility that in the near future, if there were to be more evidence again of other wrongdoing arising from a completely different set of other new facts, he may well be arrested again, and he may be expected to appear before a court. Of course, you are right that an arrest is one form of securing an accused person's attendance before court. In some instances, this particular accused person could simply be invited to present himself for processing at the nearest police station on the morning of his anticipated appearance in court. But the fact that he was not given that option does not mean in and of itself that he's being given the short end of the stick. It's simply the rules as they are meant to unfold.
So I like the concepts that you talk to being processed into the system ahead of appearance in court versus out and out arrest. It leads me to the question then, his arrest this time relates to the murder of Emmanuel Mbenze. Does the gravity of the alleged crime weigh in on the question of whether or not to arrest, whether arrest is appropriate, or does it only matter that you will appear and stand trial? In other words, could he have been warned to appear in court in relation to what is clearly a grave crime that he and others are accused of?
Usually, and in the ordinary course of business, you don't get invited to present yourself if you are facing a murder charge. But that possibility still exists. It was open to the state. Already knowing the profile of the person involved, they could have simply invited him to present himself for processing as opposed to an outright arrest. But the fact that they went to the option of the outright arrest route does not mean that they made a mistake or they acted outside the confines of the law. It's an election that they made, and it is unsurprising if one has regard to the seriousness of the charges that he is now facing in respect of this particular count.
One imagines the complexity of multiple matters before multiple fora for both the prosecution and the defense. What do you believe will be the approach going forward? Are we likely to see a consolidation?
Well, a consolidation works best in instances where the cases arise from similar set of facts and where there are no other co-accused persons. The complication with the consolidation in this matter is that it strays a variety of different persons who may not necessarily be co-accused in respect of other matters to be consolidated. So it does pose a pragmatic problem. Yes, consolidation is notionally possible, but in this particular set of circumstances, it would appear that we are already in the province of each separate trial proceeding on its own basis. To the extent that there may be similarities both on the cause of action, or the facts that gave rise to these charges, and also the similarity of the co-conspirators. In those instances, a consolidation may be feasible, but I don't see how that's going to be feasible in this particular set of circumstances. And of course, it is not a wise use of judicial time and resources, but on the other hand, the state dominates the proceedings in terms of legal proceedings, and they decide who to charge, what charges to put, and in which forum you are going to be arraigned. So it is unprecedented, but it is something that our judicial system has the capacity to handle quite effectively and efficiently.
All right, let's leave it there for this evening. Thank you for your time and your insights. Legal expert, senior legal practitioner Zola Majavu.